So for a buyer, in case they are facing a problem, the first step should be to go to the RERA or what, or to find a lawyer.
What is the problem? You go to see a doctor and you tell them that I have a problem. What is the doctor going to ask you first? Where is it hurting? What are the symptoms? Exactly. So similarly, a lawyer, when you go to him and you say that I have a problem with my property, he will ask you, so where is the property? What is the problem? Now, I see a difference in work in Delhi and I see a difference in work in Gurgaon. Now, Delhi is mostly, the problem is, I'll tell you how. Delhi was only settled as a city in 1911 when the British decided to move the capital to the city. So it's only about 100 years old. So a lot of colonies in Delhi were actually given to refugees who had come from West Pakistan or West India at that point of time, who got settled in various parts. Now these people eventually then settled down, they got allotted these houses and they had their families of their own, right? So you had hum do, hamare do, and maybe a third generation now. So you had the 200 square yard house on which you built 3 floors and which now everyone wants to, let's say, you know, the nuclear setup family in our country is going down. So people want to go their separate ways. So in Delhi, what I see a lot of legal issues concerning real estate property is, how do we divide this property? Okay, we have, let us say, 2 people, get a lot of questions for wills, for gift deeds, for partition suits. Essentially, these are people who are saying that my mother and father were the owners of the land, they built 3 floors over there, and how do we divide the floors? So how do we partition commonly held property, right? It's also called, in the UK, we used to call it tenancy in common, right? That we hold a share in the property, but it is not demarcated. What do I mean by that? You see, if your mother and father, let's say, are the owners of the land underneath the property, as their class 1 heirs, you obviously have a share after their demise in the property, right? So you have a share, but that share is not specified. You can't go to the first floor study room and they say, this is my room. I mean, obviously you can say it to your sibling, but you can't point to any part of the house and say, this is my share. So what you have is something which you own or which you hold commonly, but which you can't demarcate. So this happens very commonly in joint family property actually, when the property has been purchased out of the common funds, and they are in the name of, let's say, the male members of the family. So you have person A, Mr. B and Mr. C, who are now owners of one plot of land. A parent's example actually won't be the best for this. So you have 3 owners of the land, and person A wants to separate out from the rest of the family. Now you have one 200 square yard property in somewhere, let's say in Green Park. So how do you partition that property? That is the most common question that comes to people's mind. Now, and unfortunately we haven't reached that level of sophistication where we can resolve it internally. So a lot of people then turn to property lawyers for their trained expertise and their trained, how do we resolve this? So the way of resolving this is that you either draw up a deed of family settlement. If all the partners, let's say if Mr. A's family, Mr. B's family and Mr. C's family agree that you take the ground floor, I take the first floor, I take the second floor, then you go to the sub-registrar's office and you get the floors registered separately. So that tomorrow, in case you want to sell it to the open market, you can sell it, exit, and then, as I call it, cash out.
So there is a registration fees for it again?
Registration fees there, it's nominal. It is a couple of thousand rupees. But again, the difficult part is not the registration fee. The difficult part is agreeing to separate it like this. Now, a lot of times in my scenarios, I don't find people agreeing to partition property. Everyone wants the ground floor because it's the best floor. Okay. Also in Delhi, interestingly, if the road is broader than 150 meters, अगर आपका frontage लगता है and वो चौड़ा है 150 मीटर से, then you can do commercial activities. So suddenly the value of ground floor goes up. Now the question is, what do you do in that instances? Then you file a formal partition suit. I call it a CSOS, civil suit original side, and you ask the court for a decree of partition. Now once that interim then the procedure follows.
Sure.
The procedure for a partition suit, now this feels like a civil procedure code card class, is that I think there is a Partition Act of 1913 or 1915 thereabouts, the early 19s, which basically says that in case you have a property which is owned commonly and which has to be partitioned, you do an internal bidding. So you put a value to every floor and you say whoever from Mr. A, Mr. B and Mr. C's family can pay the highest. Let us say the ground floor is worth 2 crores, the top floor is worth 1 crore and the middle floor is 1.5. So we do a bidding. Whoever has 2 crores will pay the 2 crores, take the ground floor and get away. Whoever has 1 will buy the 1, whoever has 1.5. So you do a bidding where whoever has money can buy it and then get away. The problem, however, is that no one has the money also. That is why I'm telling you, the role of a lawyer, it seems very easy and it's very understated, but it is very, very crucial. Now the problem is when you don't have the money also and you can't do an internal bidding where you can apportion the property in 3 separate ways. What do you do in that instances? Now in that instances, you obviously go to the court who then sees whether your right is genuine or not, whether you have not, you're a genuine family member, whether there was no illegitimate child born, whether the families, it basically tracks the family tree. Now secondly, what the court will pass a preliminary decree. In the final decree or before execution, they will say that okay, you can't afford to buy it, you don't have the money, sell it in open market. Sell it in open market, sell the ground floor separately, sell the first floor separately, sell the entire building, and whatever money comes you divide it 3 ways. Right? So you have separation like 1/3, 1/3, 1/3, which is going about happening. So that is something which I see most commonly in Delhi, because you have various members of family, you have one piece of land, and usually family members can't come together in terms of that. So then the job of a lawyer is then less of what the law is, but what is to be done in a family social setting, which is why I always call the lawyers as social doctors. Like we are doctors, but we are not the doctors of the body, we are doctors of the society, because we are trying to help 3 set of warring family members to come to a mutual agreeable decision about what is to be done. So that is the commonly.
So that was the problem with dividing. What my initial question was, for what instance do you go to RERA then?
Good question. RERA you will go when you need to fight against a developer. I'm sorry. Sure. RERA you will go when you need to fight against, not amongst yourself, but you need to fight against the private limited company which has got 15,000 square feet of real estate, prime location, located in tier 1 cities, offering multitude of SED services to the marketing pitch. Best Aravali view or best lakeside view. So more so in the primary market, when you think that okay, let us say in the prospectus he had said my area will be 2,000 square feet. Now when he says that you come for delivery, he's unilaterally increased it to 4,000 square feet. And now he's saying, let's say the 2,000 square feet was 1.5 crores. Now he's telling me you pay 3 crores. Now when I booked any property, coming back to our original example, when I go to purchase a machinery, and if I say I need it to be this much in height, this much in length, and when you say that I made a machine or I made a house double the size, and you demand extra money from me, that is extortion. Because I may or may not have the capabilities of paying for it directly or picking up a loan for that directly. So RERA essentially is, let's say, for misrepresentation in the prospectus. Another common grievance for RERA, like I said, is delayed possession charge. Because before RERA came, everything was in the air. Things used to happen a little, I would say, kacha. Things weren't so solid. So that is another instances where you say that my possession has been delayed, and I either want a refund which is whatever money I have paid, you have to give it back to me at SBI's MCLR, which is marginal cost of lending rate, plus 2%. So give me back the money with interest, or give me the property, but give me interest on the money that I paid you. So I'll take the possession, but you give me the interest amount separately. So in the first instance, it's principal plus interest. In the second instance, it's possession plus interest. So that is very commonly again a grievance that you go to RERA for. Other small, I mean, it's mostly, I would say 75% of the cases in RERA are one of these three things.
Okay.
There are also, at the time when you go for possession, a builder will say that you have to pay me 3 lakh rupees as external development charge, 10 lakh rupees as IDC. I installed a clubhouse, by the way, which is again 2 lakh rupees extra. Oh yeah, remember that sewage line that no one repaired? I also repaired that. So they ask you for these random and arbitrary figures at the time of possession. So you sincerely paid for 7 years or 4 years or 3 years, and you thought that you have made 100% of the payment. When you go there to actually take the possession, you come to know that there is 30 lakhs still due. Then again is something that you go to RERA and then you complain and say that, listen, these are charges which are arbitrary. I never asked for a clubhouse. I didn't say you give me a basketball court which is indoor, which is also has a swimming pool under it. I just want a place to stay. Or that the space was less, the balcony area was more. So, minor disputes. So we'll have RERA essentially now become more of a, forum which is focused on these kind of disputes. At least that's what I see the future of RERA going to. NCLT will be more to do with whether the company has money or not. That will be more what are the balance sheets, what are their assets, can we take this company forward, should we liquidate it. So as a macro, but on a micro level, you go to RERA, on a macro you go to NCLT. But again, like I said, when you're fighting against the big guy,